Imagine if we saw the potential of refugees, not the imagined risk, the opportunity, not the fabricated crisis, compassion, not fear. Just imagine. This is a quote from the founder and CEO of the Asylum Seeker Resource Centre in Australia, and so something I think is important to begin this debate with, and for everyone to keep in mind in the context of this motion. The number of refugees, asylum seekers and internally displaced people worldwide has for the first time in the post-World War II era exceeded 50 million people, which is truly astonishing. When I see this figure, I think of the 4,300 plus asylum seekers, over one-third of which are children, here in Ireland that are living, if you can call it that, in the 34 direct provision accommodation centres across the country, in inhumane conditions, not fit for the 21st century. This system must end. For 14 years, people from these centres have been coming to me desperate for assistance. Some of them have been there for over 10 years at this stage. I know from their experiences and from my own experience in representing them that these centres are not fit for purpose, effectively operating as open prisons. Particularly, I have concerns about the protection of children in these centres, many of whom were born into this system and know no better life. While there has been much talk lately on reforming the system, the government has done little on the matter. The Direct Provision Working Group, which is being set up, will not result in the reform that is required because they are being asked how to improve the current system when it's an alternative system that is actually needed. Concerns raised about direct provision since 2001 have included the lack of any real legal basis for the system of direct provision, the reports of poor food quality, infestations, cramped living conditions, individuals institutionalised in direct provision for several years. Recently, reports of prostitution and safety issues for children are also nothing new for anyone who has worked in this area, despite these issues only receiving media attention quite recently. Because there is limited choice of food, movement and shared living space, curfews and a restriction on visitors to the centres, it is claimed, and rightly so, the system breaches the right to private and family life in Article 8 of the Convention on Human Rights. In fact, some of the asylum seekers I have worked with are unable to attend the debate today and tomorrow because they can't miss their curfews. Despite the recent media attention this issue has been receiving, and about time too, I may add, I've been wanting to raise this issue during my allotted time for private members' business for nearly a year now. So when it started receiving increased attention over the summer, and it seemed clear that announcements were pending, I briefly considered whether there was any point in continuing with this motion if everything was on the precipice of great change. Then earlier in the summer, Minister Fitzgerald ruled out the matter of extending the right to work for asylum seekers to be even considered. And then the working group was announced, and reserved comments from Minister Fitzgerald continued. Everyone here who has an interest in the direct provision system can tell you what needs to be done, because the experts have been telling us for some time now. While I'm sure there are good intentions from the Minister of State for Equality, Eoin Reardon, this is just another delaying tactic by Fine Gael and will result in a much diluted version of what has to be done. And that's just not acceptable. I think most people here will agree at this stage that the current system just won't do. And I'm glad the issue in that regard has moved forward, even though there is still an undercurrent of discrimination against asylum seekers fed by a flowing of misinformation. But this motion is not about fixing the wrongs in the direct provision system. It is about constructing an alternative, and that's how I want to bring the debate forward. This motion calls on the government to abolish the direct provision system and introduce specialised reception centres operating as one-stop shops for newly arrived protection applicants, providing access to the necessary services for the identification and assessment of needs. Provide appropriate accommodation which respects family life in a system that embodies the best interests of the child, as well as identifying and properly supporting individuals with special needs and vulnerabilities. Ensure the availability of early legal advice and independent complaints and inspection mechanisms. Provide for the transfer to independent living within 6 months if a decision on a person's status has not been reached by then. Introduce a strategy for implementation of the new system with a clearly defined time frame to adapt to a reformed system of accommodation for asylum seekers. To lift the prohibition on employment to allow residents of direct provision centres to actively participate in society, giving them a sense of worth and purpose in their daily lives, which is a basic need for every human being. and introduce a mechanism that allows asylum seekers that have already begun the process of applying for asylum in Ireland and who are therefore unable to avail of the single procedure to be fast-tracked to ensure no further unnecessary delays ensue. This issue goes beyond party politics. It is a human rights issue, and I would therefore urge all parties and independents to accept this motion. The UN Human Rights Committee observations last July rightly put Ireland to shame regarding our direct provision system, when the committee expressed its concern at the lack of a single application procedure for the consideration of all grounds of international protection, leading to delays in the processing of asylum claims and prolonged accommodation of asylum seekers in direct provision centres, which is not conducive to family life. It recommended that Ireland takes appropriate legislative and policy measures to ensure a single application procedure with a right of appeal to an independent appeals body without further delay. It also recommended that the government should ensure the duration of stay in direct provision centres is as short as possible and to introduce an accessible and independent complaints procedure in direct provision centres. This government appears to think that the introduction of a single application procedure for protection will solve everything. But the proposed legislation will have no impact on the thousands of asylum seekers who have been left waiting years for a decision on their status. With this number continuing to grow, while there hasn't even been draft heads yet for the proposed protection bill. But regardless, any time spent in centres accommodating asylum seekers should adhere to basic human rights, however short the duration of their stay. By only fixing some of the problem, all you are doing is papering over the cracks. Mrs. Justice Catherine McGuinness put it very aptly when she warned that a future Irish government will have to issue a state apology to and compensate former direct provision residents, particularly children. Last summer we learned that social services have been alerted to over 1,500 cases involving young asylum seekers, with the issues investigated by child protection staff including inappropriate sexualised behaviour among children, the inability of parents to cope, young people not being supervised and mental health problems. Additionally, this figure indicates the volume of reported concerns over children living in direct provision accommodation are between 3 and 4 times the rate of young people living in the general community. The 2012 report from the Special Rapporteur on Child Protection, Geoffrey Shannon, highlighted the real risk of child abuse in direct provision accommodation arising from the shared sleeping arrangements, whereby single-parent families are required to share with strangers and teenagers are obliged to share with parents and siblings of the opposite sex. The E grade given by the Children's Right Alliance in their report card for 2013 for right to equality and non-discrimination exemplifies how asylum-seeking children are being treated in this state. Article 2 on the UN Convention on the Rights of the Child requires the state to ensure that children are not discriminated against, including in relation to the status of their parents, and Article 7 stipulates that a child shall have a right to a nationality. The UNCRC has affirmed that the enjoyment of rights stipulated in the Convention is not limited to children who are citizens of a state party, and must therefore, if not explicitly stated otherwise, be also available to all children, and that includes asylum-seeking children, irrespective of their nationality, immigration status, or statelessness. The UNCRC has also called on states to ensure that all young children are guaranteed access to appropriate and effective services, including programs of health, care and education, specifically designed to promote their well-being, and that particular attention should be paid to the most vulnerable groups of young children, and to those who are at risk of discrimination, which includes asylum-seeking children. We all know that we are failing miserably in the protection of asylum-seeking children, and it's widely known elsewhere too. Last year, authorities in the north sought to return a Sudanese asylum seeker and her 3 children to the Republic, where they initially sought asylum. But the High Court in the north prevented the move, on the basis that returning the family to direct provision was not in the best interests of the children. The well-being, both emotionally and financially, of the primary carer, and the importance of that to the well-being of the children in her care, would point significantly to the best interests of the children being to remain in Northern Ireland, Mr. Justice Stevens found. That's a sad indictment of the system in this state. As a priority, children must be accommodated in a safe environment where their welfare can be protected and their natural development nurtured. Essentially, parents need to be able to parent and to be as self-contained as a family unit as possible. For child protection to be at the heart of the reception system, appropriately trained staff should be present within the accommodation system and not simply at a national central point with remote access. As most people know, Ireland is one of just 2 EU member states where asylum seekers are prohibited from working after a designated period. The government argues that extending the right to work for asylum seekers would almost certainly have a profound negative impact on application numbers, but there is absolutely no evidence to support that claim. The Health Service Executive has documented the negative health effects of not being able to work among asylum seekers. Lack of entitlement to work when this restriction extends over a long period may further compound the mental health with boredom, depression, sense of isolation and loss of self-esteem commonly reported symptoms, concluded a recent report. When you're denied the right to work, you're denied the right to provide for yourself. You're denied your individuality and responsibility, and there's no sense of control in your life. As aptly put by an academic and journalist on the matter, to deny the right to work is to deny a fundamental source of human dignity. Work contributes to a sense of self-worth and is essential to well-being. It can be a vital coping mechanism, particularly for people who have suffered trauma and upheaval. That is one of the reasons why the right to work is enshrined in international treaties, including the Refugee Convention and the International Covenant on Economic and Social and Cultural Rights. To deny asylum seekers the right to work is to put their mental and physical health at risk. The fact is, our direct provision system has cost the state an extortionate amount in the last few years, but is providing little in terms of a decent standard of living. The state has given more than €850 million to private firms for the provision of accommodation and food since direct provision was established. Many of these companies are large firms involved in the property, hospitality or catering businesses. Several have moved to shield their company accounts from public scrutiny, and in some cases their beneficial owners include companies in offshore jurisdictions such as the Isle of Man or the British Virgin Islands. While many cynics would use this information to argue that we already do too much for them, or should send them all back home to where they come from, the fact is these costs exist because of the reluctance and the resistance to deal with minority groups living in and being processed through an ineffectual system. If the asylum process didn't take so long, with residents spending many years in the system, costs would be immediately cut. But as mentioned previously, the single procedure in itself is not the answer. Even by introducing a self-catering system instead of handing out millions to private companies would introduce more transparency as well as respect for family life. For me, it's not about costs as much as it is about how we treat our fellow human beings. But there is no denying that there is a cost and transparency element involved that, if rectified, would in fact improve how we treat asylum seekers. Archbishop Desmond Tutu has said, "When we oppress others, we end up oppressing ourselves. All of our humanity is dependent upon recognizing the humanity in others. Where is the humanity in the direct provision?" What is needed is an alternative system that respects the human rights and basic needs of each individual and family for the duration of their stay. A system which is efficient and transparent and allows asylum seekers to be productive in society, not imprisoned, living a life of degradation. I believe what is proposed in this motion would do just that. I know that a number of deputies across all parties and none feel very strongly on this issue. I'm also aware that yourself, Minister, has had a particular interest in this issue as a backbencher, and you have stated your wishes to completely reform the system numerous times since entering office. I would consider ourselves to be similarly minded on this issue, and in that regard I hope that you are given the space to do what you're in the department to do. We have a responsibility as a nation and as a member of the Human Rights Council that when people come to our country looking for protection, they are treated with the dignity and respect that should be afforded to all human beings. Living in the knowledge that they and their children will be safe for however long they remain in our country. I am therefore calling on the government to accept this motion and introduce a strategy for the implementation of the new system and begin on a path of meaningful